Um, as I do with all of my programs, I try and divide them up into subject matter areas so that when we have a number of cases in those areas, we can see some trends. And that's what I've done here. So as we go through the various items, hopefully there'll be some trends that I can point out to you. Also, just wanted to mention very briefly, in your materials, we also included some information on what we've put together, which we call the zoning audit. And really, it's in response to some of the work that we've done, and also in terms of these case law updates, where we have noted that a number of municipalities had been struggling or had lost cases that really they should have won, many times because their zoning laws were not well drafted. And so this is something that we put together to help municipalities strengthen their codes. Not going to catch everything necessarily, but certainly it's aimed at least dealing with a lot of the low-hanging fruit. Now, I'll point some of these things out as we go through the program. The first topic that we're going to discuss is the interpretation of zoning codes. And what I've included here on the first slide are the basic rules that courts apply when these issues come up. The first is that they defer to the zoning board interpretation where the issues are factual in nature. They do not provide any deference on legal issues. And the last principle is that zoning laws are strictly construed against municipalities, ambiguities resolved in favor of the property owner. And the reason for this last rule is that we have a principle under New York law that laws, statutes, regulations that are what we call in derogation of the common law are strictly construed. And what that all means is this, is that under common law, landowners could use their property in any way they wanted to up until the point where they created nuisances either for the public at large or for adjacent landowners. Those are the basic limitations on the use of property. In modern times, we've imposed zoning laws also as restrictions on property uses. And so zoning laws restrict the uses that property owners had beyond those restrictions that were in the common law. And so any of these additional restrictions, while they're certainly legal, the principle is that they are strictly construed against the drafter, against those municipalities that are imposing the restrictions. The last point I'd like to make is this, before we get on to the cases themselves, is that it's important to keep in mind that it's the zoning board that is the final arbiter at the municipal level of the interpretation of the zoning code. The governing body, town board, village board, city council, adopts the code, but it's the zoning board that has the final word on interpreting it. That may come forward either as an appeal of a ruling of a code officer. It may come forward as a referral from a planning board. But ultimately, the zoning board is the only administrative board that has the authority and the jurisdiction to make those rulings. Okay, the first case that we're going to discuss is a relatively simple one. The issue here was whether maintenance of chickens on a residential property was a permitted use or not, and the zoning board concluded that it was not. The applicant sought a ruling in its favor because he argued that in a residential district he could use accessory uses, and argued that this was an accessory use, but the zoning board concluded that it was not the case, that even though it was not the principal use, it was not accessory because it was not customarily incidental to a residential use, and that under their code, agricultural uses, which contrast from residential uses, included poultry husbandry. This was a pure legal question of interpretation. Even though there was no deference on this point, the court did uphold the zoning board. The next case is an important one, I think, because it puts a little bit of sheen on this final rule, which talks about ambiguities and strict construction. The court here is saying that there are some practical limits to that, and that even where something is not addressed, and even where there may be some minor ambiguity, the court will still be willing to offer some minor interpretations. Again, the ruling here involved the question of whether the manufacture of asphalt from raw materials was a permitted use or not a permitted use, and the zoning code, the ruling here was not whether manufacturing of asphalt from raw materials, but from recycled materials was a permitted use. The zoning code did indicate that the manufacture of asphalt from raw materials was a permitted use, but did not directly address the recycled asphalt. There's a mistake on your handout there. The zoning board determined that the recycled asphalt was permitted because they concluded that the intent was to permit the manufacture of asphalt, and that the issue of whether the materials going into the production process was raw or recycled was not the point of the zoning code, and therefore they concluded it was a permitted use, and the court upheld that.
We had a question to ask if you could explain strictly construed.
Well, strictly construed means that the courts are not going to look to any arguments about what the intent was. They're going to look at the language on its face, and they're not going to look to external sources about, you know, why it was created, why it was adopted in this particular way or not. They will look at the code on its face and will address a common sense interpretation of that. And we're going to have a case coming up that involved the town of Clifton Park, where I think that point is going to be illustrated. So that's really what's intended there. Again, I think I would look at that in conjunction with the notion of finding or holding ambiguities to be or holding any ambiguity against the municipal drafter of the law. So if the municipality in drafting the law has left something ambiguous, something that could be subject to multiple interpretations, the courts are going to be, leaning towards an interpretation that is not favorable to the municipality, again, because the municipality was had the opportunity to clean it up. And if there's going to be a restriction that's placed on a landowner, the municipality needs to make that as clear as possible. The next case involved a question about whether a tire sales and services use was to be considered a conditional use or an as-of-right use. And let me just digress for a moment to tell you the difference between those two. In general, all of the uses that we have are divided into uses that are permitted uses and uses that are prohibited uses. And the permitted uses are further divided into what we would call as of right and conditional. As of right uses are uses that only require what we call non-discretionary approvals, which would be like a building permit. If you could walk into your town hall and say, this is what I want to do, this is what I want to construct, and give them, the plans that were necessary for the building permit, and they just give you the building permit without having to go to a zoning board or a planning board for any other approval, that's what we call an as-of-right approval, or an as-of-right use. On the other hand, as we know, there are other uses which are permitted uses, but they do require something beyond a building permit. Sometimes it's site plan approval, sometimes it's a special use permit, whatever it might be. So these uses are permitted. They are consistent with the town's comprehensive plan, but the town feels for whatever reason, or the municipality feels for whatever reason, that some additional controls are needed. And those controls, as we said, are in a different category, which we call discretionary. When we have a building permit, whether you meet the building code is pretty black and white. The code is very detailed, and the building officer doesn't have much judgment that he or she needs to use to decide whether to give you the building permit. But when you get into areas like, for instance, special use permits, it's not just that it goes before a different entity, in this case, let's say that, for instance, the zoning board, but that the permit itself involves the exercise of considerable judgment. So, for instance, in some cases where we have a special use permit, one of the standards may be that the health and welfare of the community is protected. I think it's obvious that that's a much broader standard and requires a lot of judgment, whereas, of course, as I said before, when you have a building permit, there's very little judgment involved. So all of the uses that require anything going before the planning board or the zoning board are conditional uses. And so that was the issue in this case. Was it an as-of-right use? Could the applicant, landowner, simply go in and say, here are my plans, give me my permit? Or was it possible that he was going to have to go before board? In this case, I believe it was site plan approval that was needed. And again, this is an interpretation of the code. He argued that he should be, this was a general business district, he argued that what he was doing should be classified as retail sales and automotive services, and the competing provision, which involved tire sales and services, was a conditional use. The zoning board there interpreted or concluded that the more specific use, the tire sales and services, applied. Again, there was also a provision in the code which said that in terms of if there were a conflict between provisions, the more restrictive applied. Tire sales, of course, is only a real subcategory of retail sales, and so that was the zoning board's decision. The court agreed that you needed to look at the code as a whole, and that if it were decided differently, then this additional language for tire sales and services would really be meaningless and unneeded. So again, even though this was a legal issue, there was no deference involved. The court did agree with the zoning board's ruling on that. It was upheld. This is the case that I referred to before when somebody asked the question about what do we mean about strict construction. This is a case where the developer on a very large parcel proposed building 74 one-family dwellings, and the zoning board concluded that that couldn't happen, that he could only have a one single family dwelling on the parcel, which is typical. But in the case of the Clifton Park zoning code, there was a provision that in this district, the business district, that there could be multiple buildings on the same parcel so long as the overall density limitations were not exceeded. And it turned out that that was the case. Again, this was a very large parcel, and therefore without going through any kind of a subdivision process, they argued that they could fit 74 dwellings on the parcel and meet all of the density limitations. The town argued that these residences or dwellings should be distinguished from buildings. The code said you can have multiple buildings, but the town argued, well, single-family dwellings are not really, or should not really be regarded as buildings. That argument did not go very far, and even though it was pretty clear from the code and from the history of the code that the town did not have something like this in mind at all, on its face, the code simply said that multiple buildings were permitted as long as the density limitations were met. They were, and the court ruled against the town, and that was that project was approved. The next case is an interesting case from a different point of view. The setup is that when somebody wants to get an interpretation of the zoning code, they first go to the code officer. And if they're not satisfied with what the code officer has told them, they can appeal that to the zoning board. Again, this goes back to what I said at the outset, that the zoning board is the final arbiter of what the interpretation of the code is, subject, of course, to judicial review. But at the local level, it's the zoning board that has the final word. So in this case, there was a project along Lake George that the zoning officer had advised the property owner needed an area variance. Some of the people who lived in the area, they were not immediate neighbors, but people who were at least interested in this project and opposed the project went to the zoning officer, code officer, and argued that no, that they needed more than that. They needed a use variance, and that they asked him to make that determination. He did not do so. So unsatisfied with his reading of the zoning code, they went to the zoning board. And this is a typical situation where, again, not satisfied with what the code officer tells you, you go to the zoning board. The difference, though, was that the typical person who goes to the zoning board is the property owner, is the project proponent, and here it was some people who were third parties who really opposed the project. The zoning board looked at the statute, this is in the town law, and they concluded that these parties didn't have any basis to file the appeal. Not they didn't have any basis in terms of the merits, but that they didn't have what we call in the law, they didn't have any standing. They didn't have any legal right to bring the appeal. And they did that based upon the fact that under the town law, the party appealing to the zoning board has to be, as we say in the slide, aggrieved. And they interpreted the term aggrieved in the same way that the courts have interpreted the term and interpreted the issue of standing. So for purposes of this issue, whether they were aggrieved, they concluded that the parties involved had to show that the ruling would create some injury from them, but not just an injury that was common. It had to be an injury that differed from other members of the public at large. So, for instance, if you have a situation where a project is going to cause a lot of traffic, that injury is going to be common to a lot of people in the community. On the other hand, if you live immediately next to the project where you're going to be affected in a way that is much more significant than other people simply traveling on local streets, that gives you the opportunity to say that you have an injury that is different from the public at large. Here, these people were not neighbors. They didn't have any proximity, or they didn't live in proximity, even though they were interested in the project. The zoning board ruled that they were not aggrieved. And so they said in the judicial context, they use those terms too, and they use also the concept of standing. This is pretty much the same thing, but at the local administrative level. This ruling, they made that ruling. They went forward. They didn't rule on the appeal itself. They went forward and they granted the area variances. And these parties, the Fund for the Lake George, the petitioners went in and they argued that they should have been, the zoning board should have dealt with their appeal, and they also appealed the area variances that were granted, and the court, along the same line of thinking of the zoning board itself, said you don't have any standing, you're not aggrieved, you are in no way connected to the project, that the project itself creates an injury for you that differs from the public at large. So again, this concept that the zoning board only has to address appeals by aggrieved parties is now established by a court case.
Bob?
Yes.
Can you address cases regarding sharing economy rental of residential homes? That's one question we had.
Could you repeat that again, Kathy?
Sure. Can you address cases regarding sharing economy rental of residential homes on Airbnb? And the third department came out with a decision on November 25th.
Well, I don't have any specific knowledge of that case. These cases really chronologically run from the middle of 2014 to about the middle of 2015. So maybe next year it'll be included. But the only thing I can say is this, is that there have been a number of cases that I'm aware of, particularly where I've seen them are in Adirondack towns, where there has been an issue of whether a residence is being used in a commercial way for rental purposes, and in that case, how it should be classified under that zoning code. I think the bottom line on all of it is that there's no general answer to that question. The answer to that question depends in large measure on how the zoning code is drafted. That if the zoning code is properly drafted to get at the situations that the town or village board seeks to control, they'll be able to do that. But in many cases, the zoning code has not been well drafted, and again, courts have then fallen back to the principle of, if it's ambiguous, we are going to decide it in favor of the property owner, because the property owner really is not on notice of this restriction. So again, this goes back to what I talked about at the very outset, which is that a lot of cases where municipalities have the authority to do things, sometimes the municipality gets tripped up because the zoning code itself has not been well drafted, and that's a reason that they wind up losing some of these cases. And again, this was the reason that we talked about trying to help municipalities with some sort of audit. And, you know, for instance, looking at things like definitions and classifications and things like this, because these are very basic issues in drafting a local law. And sometimes these local laws, of course, have been on the books for a very long time. Sometimes uses or the way that properties wind up being used commercially change over time, and the definitions and the use classifications all of a sudden are outdated. So again, we've seen that happen. So that's the best I can do. I haven't seen that case yet, and but it may well be in the next one, next year's.
Okay, and then
was there another question, Kathy?
There was. In the case of a town without zoning regs, writing them for the first time, does this issue need to be addressed in the local regs when they are first written?
Does what issue need to be addressed? I'm sorry.
That I am unsure of. That was not included in the question. So it would have been on your last topic.
Well, I think that the long and the short of it is whether...
Oh, I'm sorry, Bob. It's referring to the Lake George question.
Okay, in the Lake George question, the Lake George question really gets to the issue of whether the zoning board has to hear an appeal or not. And that's not a question that involves how the code is written. What this is saying is that if somebody does not agree with the interpretation of the code officer or zoning officer, whoever that administrative person is, and they want to take it the next step, in other words, to appeal it to the zoning board, they have to show that they are aggrieved, or in other words, they have to show that they are suffering an injury that is not common to the public at large. This has really nothing to do with the drafting of the zoning code itself. It really has to do with whether a third party is closely or closely enough that they're affected in a very unusual way. So, for instance, if they're claiming that, you know, there's going to be some their view is going to be affected by whatever construction is involved, they would really have to be a very close neighbor in order to have standing to pursue that claim. If they're going to claim, you know, that there's going to be a significant amount of additional traffic or something like that, it's not enough to simply be somebody who is a resident of the town and drives those roads. You have to be somebody who is almost immediately adjacent to the property. So it's not an issue that really is really tied up in the drafting of the zoning code, whether it's the original drafting of the code or amendments to the code. It's merely a question of whether anybody who is not the property owner or the project sponsor has the right to challenge a ruling regarding the project. Okay. The next topic is the official map. There is reference to the official map in the various town, village laws, general city law, but the way in which the official map affects zoning decisions is not laid out in those statutes. Some local governments have put something in their codes, for instance, where they will say if there is a discrepancy between an official map and the text of the zoning code, that the official map governs, or they might say the text governs. Okay, but it's a local code provision which says what is the impact of the official map. in this case, again, this goes back to the same Clifton Park case that we discussed before. The town never really had an official map because it was never filed properly. There were, and particularly with this zoning, a recent zoning change that was in controversy in this case, the town had never filed any kind of map that related to the new zoning, as was supposed to be done under their local code. And so the court was confronted with the question of whether that zoning change should be honored or not. The code itself stated that the map, together with the written description, were to be filed with in the county and also the county clerk's office. But again, no map was ever filed. And the court, in this case, ruled that the failure to file the map was not fatal, but that the written description, which were associated with the zoning change, would govern. This case is not necessarily something that can be extrapolated to other towns or other villages or whatever, because it really depends on what your local code provision makes of the official map, what status gives to the official map. But there have been other cases, for instance, where as I mentioned before, the local code says in the case of a discrepancy, the zoning map governs, and even though there have been zoning changes, in those cases, the failure to update the map is a problem because now the zoning changes are not properly reflected in that map, and the local code says that that map is the governing document. Okay, the next group of cases that we're going to talk about involve area variances. As I think most of you are aware of the fact, area variances are situations where the use itself is permitted by the code, but one of the what are called sometimes the bulk requirements, setback requirements, height requirements, and things of that nature, those are not met. So in New York, we have in the statutes 5 criteria that have to be evaluated. All of these criteria that are laid out right there in the slide are things that are potentially unfavorable to the property owner. And the zoning board has to look at each of those criteria to the extent that it's relevant. And then after looking at those criteria, and this is a very important element that appears in a number of these cases, the zoning board is obligated to balance the benefit to the applicant, meaning the benefit of giving them the variance, with the detriment to the health, safety, and welfare of the community. And it's that essential balancing that is at the heart of all of the area variance decisions. Okay. So in our first case here, we're talking about a co-op that has 211 units but doesn't have sufficient on-site parking, and they've applied to build additional parking on an adjacent lot which had been used for 4 parking spaces, but now they're going to upgrade it to 28. They needed an area variance in order to do this because there were restrictions on how many parking spaces could be included there. This is a theme that has appeared in a number of the cases recently. I don't want to say that it's a trend or whatever, but a lot of courts have expressed concern where it appears to them from the record that the boards are bowing to community pressure, to opposition from the community. And The bottom line is, of course, that there's nothing in and of itself that's wrong with hearing community opposition. But I think boards are advised that, where there is a situation where there's a lot of community opposition, they want to make it clear in their decision to any reviewing court that the decision is not simply based on community opposition, but is based on some criteria that they can act upon. So here, for instance, the site had already been used as a parking lot, and the court, even though this was turned down, the court could not find sufficient evidence to show that there was a feasible alternative or that the hardship was self-created. There may have been an argument that the hardship was self-created, but it was not really pushed, and there was not enough evidence to make that finding. And so the court basically said, even though there's a substantial variance here, in other words, I don't know, under their code, they could allow, I don't know what it was, 4, 6, or 8 spots, and they were allowing 28. There wasn't really any counterweight in terms of showing how allowing those additional spots were going to hurt the health, safety, and welfare of the community. And so here the court said, you've evaluated the criteria. The only one that we feel has any weight at all is the fact that the variance is a substantial one, but all of the other findings that you've made are really without any good support in the record, and therefore they overturned the variance, saying that this was, when you balance the need with something that was only concerned that the variance itself was large, there was no need to turn it down. There was no good basis to turn it down. In this next case, this also advises the zoning board that when they make findings, they don't have to deal with all of those 5 criteria that the statute sets up. In many cases, there may not be any evidence on some of the criteria. In many cases, the evidence will be very sketchy, or the criteria may not have much relevance. So they need to make findings on the criteria where there's information and the record to make those findings, but they don't need to address all of them if the record really doesn't include information. So here, they did turn down the variance. They demonstrated that this lot was going to be a large variance. The nonconformity would be the most of those in the area, and that the hardship was self-created. What happened here was that there was a group of lots that were undersized lots, and people had owned these undersized lots, and they were able to get variances on the undersized lots over time, and a number of houses had gotten area variances because the lots, again, were all undersized as compared to what was required by the zoning. But in this case, somebody who was from the outside, somebody who did not own the lot, came in and bought the lot, well aware of what the restrictions were, and that was, I think, the issue that kind of turned the case against that person. The fact that all of these other people had gotten variances was not enough to ensure that he was going to get a variance, A, because his variance was larger than the others, just because of the way the lot was conformed, but the other thing was that he bought into the problem. And this is an important point for those of you who are not members of planning and zoning boards but might be involved in the real estate community. This is a very important point, that if you're going to buy property or you're going to be, excuse me, representing somebody who buys property, if that property needs to get some kind of a variance to build on or to build, what you would like, that variance should be gotten before the property transfers title, because the current owner may well be able to argue that they owned the property when the zoning changed, and therefore they didn't buy into the problem, that the problem essentially was foisted upon them by the change in zoning. But once you have somebody coming in new, somebody who is has a choice and consciously buys into the problem, then you're in danger of having a zoning board conclude that the hardship in this case is self-created. Okay, in this case, this was, again, a relatively small variance that was requested. It was with a residential plot, and again, there was a conclusion that the impacts, even though that it was a large variance in terms of size, that there was no impact on the community in terms of health, safety, welfare, or any of those things. And therefore, the court looked at, as I mentioned to you at the outset, this balancing. The balancing is very important so that, even though there may be some negative impacts, those impacts have, a marginal effect on the community, and the benefit to the property owner is significant, and there really isn't another way to do it. The courts are going to look at that balancing, and if the zoning board really doesn't explain why the community is going to be suffering from this variance, the court is going to say that's not a rational way to balance, and that's what happened here. Okay, here's a case, again, where there's an issue of community opposition. And again, I think the issue here was a lot depth variance. The lot depth variance was denied, and I think the court, looking at this record, concluded that there were really, even though the zoning board said that there was an undesirable change and there was adverse impacts, physical and environmental health on the community, the court really didn't find any evidence of that in the record. And so I think the court, seeing that there was a lot of community opposition to this, basically concluded that there was no substantial reason for the denial. And again, I think the courts have their antennas up for situations where zoning boards may invent reasons or exaggerate reasons or whatever in order to come up with a result which conforms to public opinion, but is really not well documented on the record. So I think, where you have a situation where the community opposes something, obviously that doesn't mean that you have to bend over so far backwards that you don't go along with what the community wants. But if you're going to do that, just make sure that your decision is documented for more objective reasons. In this case, what happened was that there's been a big issue over the years about zoning boards following the precedent established in their prior decisions. And the rule is basically that a zoning board does have to follow its prior precedent unless it can distinguish the case in front of it from those. Many people have tried to make that argument, and what they need to do at the outset is to show that it truly is a prior precedent, so that a number of cases that are similar factually have been granted, and that your case, which is again very similar, is being denied, and that the zoning board is obligated to follow its prior decisions. Here, they did not. The court didn't agree that there was a prior precedent involved. Again, the person making that argument has to really show that there is some prior precedent here. But nonetheless, the court did send it back for review. And this is not a case, as with the others, that the balancing was not rational. This was a case where the language that the zoning board used in its decision reflected that they were using what they call a practical difficulty test. The practical difficulty test was used many, many years ago, before the state adopted these statutes that established those criteria that we talked about up front. So I think the court was concerned that this zoning board, for whatever reason, was not using the criteria that was in the town law for ruling on area variances. And so instead of making that ruling itself, the court sent it back to the town with instructions that it use those criteria. This is very similar to the case that we discussed before. This case involved an accessory apartment, like an in-law apartment. It needed a number of different area variances. The ZBA wound up denying them. They made negative findings on 4 of the 5 criteria. And the court, as we saw in previous cases, said, you know, you don't necessarily have to address all of the 5 criteria if the others are well documented and the ones that you've left out are not. At the end of the day, we're concerned that you use the information to balance the negative impact on the community with the potential benefit to the applicant. We see that was done here, and also in some additional language, which we've seen in some of the other cases too, is, you know, the courts have said you got to follow your prior precedent. And this court is saying it's legitimate, zoning board, for you to consider what prior precedent you might be creating by permitting this application. So if you allow an in-law apartment here, what does that mean to others who may be applying, you know, for similar types of relief? So again, that's how they concluded that case. Now we're going to move on to use variances. Use variances differ from the area variances, as I'm sure most of you know, in that we're now talking about a use which is prohibited under the code. In area variances, the use is okay, but sometimes the layout doesn't meet the code requirements. Here, the use is prohibited in the zone. And so we have the 4 criteria that we have up on the slide. The applicant must meet all of the criteria. If you recall from the area variance, all of those criteria, or at least the ones that are developed on the record, have to be considered, but even if one or more of them are negative, it doesn't prevent you from issuing the area variance. By contrast, if any of these criteria come up in the negative, you cannot issue the use variance. It must be denied. There's no balancing here in the use variance. The applicant has to make a showing on all of these items and must show them in the affirmative. One of the toughest ones, you don't really see that many use variances coming forward. The area variance is far more common. But one of the criteria, which is always a difficult one, is this question of reasonable return. And it's easy to say, but hard to really interpret and hard to really adjudicate. First of all, you have to understand that reasonable return cannot be associated or equated, I should say, with the term profit. You could have a situation, for instance, where you have $100,000 to invest, and you could take that $100,000 and invest them in treasury bonds. And even though the interest rate is low, you would see a profit. You would get a profit over a year or over time. If you're going to make a real estate investment, that type of a profit, the same type of a profit that you would see from investing in treasury bonds, is not a reasonable return, because a real estate investment is much riskier. A treasury bond investment is a virtual certainty in terms of return. Real estate is much riskier. And so a reasonable rate of return has to be associated with the degree of risk involved. So that's one issue that has to be understood when determining whether there's a reasonable return or the ability to recognize a reasonable return on your investment. The other point with respect to this is the following, is that the courts have said you need to look at all of the uses that the zoning law permits, and you need to show that each and every one of them cannot be implemented with a reasonable return on your investment. And of course, we're talking about your estimated or projected return. So if, for instance, just to pick a number out of the air, if you want to say that a real estate investment is going to have to get a 10% annual return on investment, then you would need to look at all of the permitted uses and go through each one of them and determine individually whether they could result in a reasonable return. And if you determine that none of them would provide that reasonable return, then you can cross that first criteria off your list and look at the others. The next case that we have involves the question of, how do you set up that equation, so to speak? How do you figure out whether you can get that reasonable return? So in this case, it had been established that the existing manufacturing facility was legal. It was, as we'll talk about later, it was a legal non-conforming use. But it couldn't be expanded because that would require a use variance. And again, the reason for the expansion was to store some equipment. They needed some additional storage facility to do that. So in order to get the use variance, the issue was, in this case, how to demonstrate that all of the legal uses could not result in a reasonable return. So obviously they had to look at all of the uses that were permitted under the zoning code. In this case, they also had to look at the existing use, which, even though was not permitted under the zoning code, was legal because, again, it predated the zoning and it was a legal non-conforming use. So they had to be able to say, okay, can we do any of the things that the zoning code currently allows, or can we get a reasonable return on our investment by continuing this existing non-conforming use? Setting up this problem is not trivial by any means. And so one of the issues that came up was residential uses were permitted under the code, and they presented evidence that the residential use was not feasible, but the court rejected that analysis because they said, well, you know, this is a large parcel, and you just considered whether converting this into a one-family residence was feasible. But you could as well use other parts of the property to do more than a single residential project. And if you use the entire site, that might be feasible. You need to show whether that is feasible or not, and you didn't do that. So the court concluded that even though the variance was granted, that it shouldn't have been granted, because even though they looked at the residential use, they really didn't use or examine the residential use to the full extent that it could have been done on that property. You know, that's kind of not that clear of a question as to really how to analyze that. And so in many cases where there is a use variance involved, I think that the zoning board may be well advised to hire some kind of an outside expert to help them set up, structure, and analyze this problem. And most of the municipalities out there have provisions that if they need to hire an outside expert, they can do so at the expense of the applicant, and this would be a good use of that authority. Also, it's also worth noting that the dissent threw another wrench into the work, so to speak, because the dissent was saying, well, okay, the majority is telling you that you need to look at the entire site and to see, you know, whether there might be multiple residential residences that could be set up that would make it more feasible to do. But they didn't say that you should also consider the cost of relocating the existing manufacturing facility, because obviously if you're going to convert the whole property to residential, where are you going to, or what are you going to do with your manufacturing facility? And so the majority is saying you didn't do the analysis of the full residential build out correctly. The dissent is saying, well, yeah, but the other thing is that they have the potential for additional costs that were not counted in this equation as well, because this analysis of relocating the existing facility was also not taken into account. So these are not trivial problems as to how to set this up and as to whether indeed there are opportunities to get a reasonable return on your investment through permitted uses. Okay. That's the only use variance case. Now we're going to move on to the special use permit. The special use permit is substantially different from variances in that the special use permit involves a case where, again, we're not, remember I said at the outset that where we're talking about zoning laws, most of them are structured to divide the universe of uses into those that are permitted and those that are prohibited. The variance cases involve the prohibited side of the equation. The use variances, of course, are the uses that are prohibited. The area variances meet the use requirement, but some bulk requirement is not met. When we're talking about the special use permit, we're completely on the other side of the equation. All of the uses and area requirements for these types of projects are met. There's no question about the use is improper. There's no question about them not meeting a setback or a height requirement. They completely are in conformance with the zoning code. But the board, the governing body, has decided that these are cases where some additional oversight is needed. So again, these are not as of right uses, these are conditional permitted uses. And also it's important to keep in mind that when we talked about the variances, as you remember, at the initial slide, I included the criteria for the area variance, and I included the criteria that the statute set up for the use variance. The special use permit is a different animal. The state laws, the town law, the village law, general city law, tell municipal governments that they can have or require a special use permit, but they don't tell them anything about what the standards are for special use permits. So when you have a variance, you must do what the state statutes tell you to do in terms of criteria. You must use the criteria that the state statutes tell you to use. But when you're dealing with a special use permit program, the local government has to establish what those criteria are. And this is, again, something that we've seen with several municipalities where the municipality has not adequately established those standards. This is another area where, in terms of auditing their zoning law, we look for something like this. So this is something to keep in mind. If you're going to establish a special permit program, you also need to establish what it covers, and you need to establish what are the criteria that the board is going to have to decide on whether to issue the permit or not. Also, unlike the variances, variances, of course, as you know, are heard by the zoning board. The special use permit, on the other hand, can be delegated to any board. So the board can say these are going to be handled by the zoning board. They can say they're going to be handled by the planning board. They can even the town or village board can even retain the authority to issue special use permits themselves. And in fact, in some cases, what some towns do is that they'll establish a threshold so that projects that are smaller projects below a certain threshold, special use permits will be issued by one of the administrative boards. And very large projects, the governing body retains the authority to issue the special use permit. Okay. So in the first case here, again, it was a 7-Eleven.
Can I interrupt you for a moment?
Yes.
Do templates exist to suggest what criteria should include?
Do templates exist? Is that what it is?
Yes.
Okay. Well, no. The short answer is no. I mean, certainly you can look at other towns' special use permit programs. I think the first thing is to focus on if our town is requiring a special use permit, what is the concern? Okay, is it parking? Is it the use of hazardous chemicals? Is it, what is the concern? Is it the traffic flow of, whatever the concern is, that's where you begin. Okay, and so you say, okay, these are the things that the special use permit is going to review, and then in addition to that, you have to say, okay, we're reviewing it now. Our local law is going to have to tell us, where is the line between, what's acceptable and what's not acceptable, and that line can be, subjective. In other words, you don't have to have a numerical criteria. You can say, adequate parking, or parking is something that obviously you can attach numbers to, but other things that are less amenable to very numerical standards, you can attach words like acceptable, not impacting existing properties, or things of that nature. So you can leave it, you can put in some amount of judgment, but when that judgment is exercised, as we're going to see in this case, you have to, you have to have the goods in the record. So, and this was a case where, at least on the surface, there was a concern about traffic and parking. this 7-Eleven case. And but the record of the hearing showed that a lot of the opposition arose because of the type of clientele they were concerned the 7-Eleven would attract. And the permit was denied, citing traffic and parking. But you know, the 7-Eleven applicant provided experts on these issues, and the experts showed that, at least according to their analysis and calculations, these were not problems. So this gets to another related question of what is the role of the community in all of this, and how much do you need to look at expert reports versus testimony from the community about experiential testimony, okay? There are certain things that are amenable to expert analysis, for instance, traffic and things of that nature. So if the community is coming in and complaining about, you know, a traffic issue that a new facility is going to cause, and you as a board member see it as a potential problem, even if there is a traffic report by an expert, I think as a board member or as a board collectively, you can ask for an expert to advise the board directly. In other words, you can ask that at the applicant's expense that a separate expert be hired to advise the board independently of the applicant's expert, and that gives a board the opportunity to really be on the same level as the applicant when we're dealing with these types of issues where there are expert reports. What I think is a problem is where, you know, some boards hearing a concern about traffic and sort of being maybe sympathetic with some of the people complaining about the traffic, a board makes a decision citing traffic as a problem where there's an expert report showing that traffic is not a problem. So I think, you know, where you have an expert report and all you have is this kind of experiential testimony on the other side, you run the risk of having a court saying that your conclusion is irrational. But in order to take into account what are maybe legitimate concerns of the public, the way to do that is to require that a separate expert be retained at the applicant's expense. And that's kind of the way to thread that needle. So here, again, the court concluded that this rationale cited by the board in terms of traffic problems and parking problems really was not substantiated in the record in light of the expert reports. Maybe, again, if this board had hired their own independent expert, some different outcome might have happened, but simply relying on the local opposition in light of these expert reports was insufficient. So when you're dealing with a special use permit, the criteria have to be in the local law, and then again, that the if the criteria are met, then the permit must be issued. Another principle, it's not really from this case, but I'll just mention to you, is that the courts have also held that where you have a special use permit, if the impacts from that special use permit, or from that activity, I should say, are the same or less as of right activities, that the permit has to be issued. So if if the zoning law allows certain as-of-right activities, these are activities where you don't need to go through any kind of permitting process other than getting the building permit. If you can go in and get a building permit, and that type of a facility has the same impacts as the facility that your board is dealing with here, if the applicant can show this is no worse than this as-of-right use, then the courts have said they should be getting the permit. This case, I think, is important because it stands for the proposition that even though you have a conditioned or a conditional permitted use, it is not always the case that the permit must be issued. So here we have a situation where daycares are permitted uses. They are, however, subject to the special use permit requirement. And in this case, the evidence shows that there is a dangerous traffic situation and that there is a problem with the parking and access for emergency vehicles. So again, a zoning district can be very large. And if you have a situation where you have a facility listed as a permitted use, there may be areas within that zone that even though it's a permitted use, it is not an appropriate area. And so here, even though these types of uses, daycare uses, are permitted in this zone, the village provided for a special use permit program so that if an area that was chosen was not appropriate or some condition needed to be placed on it, on its operation, there was an opportunity to do so. So again, we get into a situation where the board concluded that there was a problem here. And again, I would just note from the caption of the case that in this case it was the Board of Trustees that was responsible for issuing the special use permit. And again, the court defers to all of these boards on factual issues. In other words, the court is saying, yeah, there's some evidence in the record that the traffic is not as big of a problem as the board found it to be, but there is sufficient evidence to support the determination, and therefore we will uphold that decision. Okay, I'll move a little quickly now. There's two topics that are related. One is called non-conforming uses, and the other is called vested rights. Okay, a non-conforming use is a use that's in effect before there's a zoning change. The zoning change makes the use no longer legal. But because it was established before the zoning change, you're allowed to continue the use. And the other piece of the other requirement is that you cannot abandon the use, that you must continue that. If at some point you do not continue it, then the non-conforming use status is lost. The other concept which we're going to deal, which is a related concept, is what we call vested rights. So with the non-conforming use, we're talking about a use that predated the zoning and was approved, it was legal, all of those things. With respect to vested rights, we're dealing with a use that has not been established yet, but is usually somewhere in the approval pipeline when the zoning changes. Okay, so the first case stands for the proposition that these non-conforming uses are not interchangeable. So if you start off doing something before the zoning code changes and now you have non-conforming use status, that doesn't give you the right to change to other non-conforming uses. You have to maintain your property and use your property for the pre-existing non-conforming use and nothing else. So here they had or could have had non-conforming use status for the gravel mining. They didn't have any such status for other uses like garage and storage, and therefore it was held to be it was held to be illegal. No legal status, and it was illegal. The next case, is the other side of the equation, where you had a pre-existing use, and it is continued, but it is not continued necessarily at the same level. So here, the court said, if you continue to use it, even though it may be at a diminished level over the years, it has not been abandoned, and hence you continue to have non-conforming use status. Local governments in their codes can establish criteria for when they're going to consider a use to be abandoned. And they can, sometimes they make those criteria absolute. I think it's probably a mistake to do that, but you can also have a presumption. So for instance, if a use is stopped for more than a one-year period, you can say, okay, now there's a presumption that it's been abandoned. But that at least opens the door for the property owner to come in and say, well, we, had the owner died, and therefore we had to look for, somebody new to take it over or something like that, or we were busy collecting on an insurance policy. So it leaves the door open for a legitimate excuse that it took them more than a year to get the use restarted. Okay, so now on our topic of vested rights, under New York law, the issue of vested rights is very, very unfavorable to the property owner. It's very favorable to the municipality. So if the municipality wants to change the zoning, and these two criteria are not met, they can send the property owner back to square one. So the property owner has to show that all of the authorizations were in place before the change in the zoning, and that a substantial investment was made. So again, the outside limits of what a municipality can do is to change the zoning and force you back to square one if you haven't done both of those things. They don't have to do that. In other words, when a municipality changes its zoning, it can look at the equities and say, if somebody is this far in the pipeline, if they've already had their required hearing, then we will allow them or their project to be judged under the old zoning. That's up to the municipal government. It's really a question of fairness and equity. But these are the outside limits of what they can do. Okay. So in this case, most of these vested rights cases have been decided in a situation where the project has to be built in stages. And what I mean by this is the following. The two cases that went up to the highest court one involved a mining project and the other involved a landfill project. In both cases, these facilities were subject to the jurisdiction of the State Environmental Conservation Department. And the department will not allow you to mine, for instance, on the entire site. So if you have a 100-acre site, the department will say, we will allow you to mine on 10 acres, and then when you're finished with that, you can start reclaiming those 10 acres and work on the next parcel of property. And it's similar with landfills, that you can't landfill all over the place. You have to landfill in one place until it's filled up and then move on to the next. Those are all, because of the nature of the regulation, they have to be phased if it's a big parcel. This is the first case that I've seen, or one of the first cases I've seen, where we're dealing with a commercial project. They were going to be building a retirement community. There were different types of buildings. One of them had the need for a height variance, which was granted. They built the project in phases. but the 3-story buildings that needed the height variance were not built. There were a bunch of changes in ownership and whatever, and when they finally went to build them, the town said, you know what, the variances that we gave you, this was probably 20 years ago, are expired now. So even though the language in the variance itself was favorable to the applicant because the variance language had been changed to eventually read that it was good for the life of the project, the court said we don't even have to look at that and figure out what was meant by the life of the project, because you know what? You have vested rights. This is a single project. It has to be looked at as a whole. And you got all of your necessary approvals for this project, and you made a substantial investment. It just so happens that these particular units were not built, but the project at the whole had a very substantial investment made, and therefore you have vested rights to continue operating under that approval. The town cannot send you back to square one. Another case, this has been subject of a lot of litigation here with the mining company of the town of Schoeneck. This is a case where there was a question of whether they were entitled to that vested rights because they didn't say, or there's a question of whether they had all of their approvals. Again, you have to show that you have all of your approvals and that you've made a substantial investment. So this case, it really only stands for the proposition that you don't always have to show that you have a permit for the parcel in question, that all of the approvals are not necessarily, or doesn't necessarily mean that you have the permits, because again, when we have these staged projects, if you can show that the original intent was to do it in a very large area, but that you were sort of boxed in to only apply area by area, if you can show the overall intent was to, in this case, mine over the whole area, you've satisfied that requirement that you've had all of the approvals. So the court said that the town's simply saying that they didn't have a permit in this case, didn't go far enough. They remanded it back to the town to take a look as to whether they needed a permit here. Okay. Seeker, this is of course the environmental review requirement that applies to all of your discretionary approvals. You know, you don't need to do seeker where there's only a building permit, but whenever there's a variance, wherever there's a special use permit, wherever there's a site plan approval, any of those are discretionary. You need to make comply with seeker. This is an interesting case because it involves the interplay between various agencies. When you have a project that's subject to approval by multiple agencies, in most cases, you're going to have what we call a lead agency. And the lead agency is the one that goes through and determines whether there should be an environmental impact statement, if there is one, what it should contain, and then ultimately conducts the hearings and issues a final document. And this is what happened here, that we had the DEC that regulates mining being the lead agency, the town of Nassau having some local approvals was what they call an involved agency, but not the lead agency. The DEC finished the environmental impact statement, and then before issuing any approvals, it issued findings. This is required under the law, that if you have an environmental impact statement, before you make any decision on your permits, you have to make findings about whether the impacts of the project have been mitigated to the extent practicable. So in the first round of litigation, which is not reflected here, the applicant, the Troy Sand and Gravel, argued that the town had to follow the findings of the lead agency. The lead agency had made positive findings, and the applicant said that's what lead agencies do. Not only do they conduct all of the hearings and make all of those decisions that I mentioned before, but they make findings too, and you're stuck with them. And the court said, no, 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 that's not the way it works. Each agency has to make its own findings, even though the lead agency conducts the process which results in the studies and the environmental impact statement. So in this second round, the town said, okay, the court has already said that we're entitled to make our own findings, and we're looking at this environmental impact statement, and we don't think that it gives us enough information to make those findings, and so we're going to give Troy Sand and Gravel a bunch of additional studies that we want them to do before we can. And the court said, no, now you're going too far in the other direction, because it's true that you're not bound by their findings, but what a non-lead agency is bound by is that they're bound by the text and the record of the environmental impact statement itself. So they cannot look at information beyond what's in the environmental impact statement in order to make their findings. It's true that they could look at that same information that DEC used to make positive findings, and they could conceivably interpret them in a different way and make different findings. But whatever findings they make must be based on the final environmental impact statement that was adopted by the lead agency. Okay, this is a small case. As you know, or you may know, all of the actions that are subject to seeker are divided into 3 different categories: Type 1, Type 2, and unlisted. The Type 2 actions are ones that, by the rules, have no impact on the environment. So once you've determined that an action is Type 2, you don't have to do anything further. One of the things that's listed as a Type 2 action is replacement in kind. So here, as some of you probably remember from the big storm that we had with Sandy several years ago, the Coney Island boardwalk was very badly damaged. And the city said, we're going to replace it, we're going to rebuild it, but we're going to use a composite material that resembles wood, not wood. And having the emotional impact of something as iconic as the Coney Island boardwalk, people said, we don't want that, we want the real thing, and if you're going to do something different, you're going to have to do environmental impact studies. The court said no. New York City said this is a Type 2 because they're calling it a replacement in kind, and we agree with them. Okay, this is a case, this is an interesting case, and in the interest of full disclosure, this is a case where our firm is representing the town of Tyre, which is one of the winners in the casino sweepstakes. And so the town board was the lead agency for the review of this project to construct the casino and resort. And the town wound up issuing negative declaration that was challenged. And what happened is that at its June meeting, June 2014, they went through a very step-by-step review of everything that was in the environmental assessment form, all of the potential impacts, and after looking at each and every one of them, there was a vote taken on each of the potential impacts, and the vote was all negative. And at the end of that session, the town asked Schoeneck King to draft a written document reflecting that rationale. As some of you may know, the courts have said that if you're going to issue a negative declaration, you have to provide a reasoned written elaboration supporting that negative declaration. So that was drafted. It was circulated and presented to the members of the town board with a request that they provide any comments, objections, whatever, and there were none received. and so that was where it lay. But it turned out that the town board, it never really took any official action on this document, which was drafted by us, and the court ultimately said that that was fatal, that the town board needed to have officially adopted that rationale, adopted that language as their reasoned written elaboration. It wasn't enough to just be silent on objections. So they rejected that, and they said it has to be sent back to the town. They emphasized that there was need for strict compliance. This case has been accepted by the Court of Appeals, and so the Court of Appeals will provide some guidance, I guess, perhaps in the not-too-distant future, about what it is that actually satisfied that requirement for reasoned written elaboration. Open meetings, we're just about done with our time here. Open meetings, this is a case where a town approved a project. The applicant, New York Safety Track, went far beyond what was approved with this motorcycle facility, training facility, and this town began an enforcement action against them, and in resolving the enforcement action, they actually negotiated kind of a new permit for them. And then they went through a very abbreviated process and issued that permit, and the court was rather incensed that all of this was done in secret and the public was not involved, and they found a bunch of violations of the open meetings law and fined the town attorney's fees and costs. These I'll go through quickly. These are federal cases. You may be aware that there's a federal law involving religious land uses. The acronym is RLUIPA, and it basically says that you cannot treat a religious institution any worse than you treat a non-religious institution. Here, the issue was a development that was approved by the town, a development sponsored by a religious organization that was approved by the town, and several of the surrounding villages sued, challenging secret compliance, and the religious organization said this is a violation of the federal law, and the court said no, no, no. The violations that this law is talking about are only regulatory. So, you know, we're talking about the town being the regulator and the villages just sort of being representatives, presumably, of their communities. They had no regulatory authority, and they were just sort of in there as third parties challenging a secret determination. That is, this court is saying that's not covered by this federal statute. There's two cases in the communications field. This is not a case from New York State, but it was a case decided by the U.S. Supreme Court, presumably applies to New York State. The Telecommunications Act restricts what can be done by local land use authorities, and basically says that if you're going to get a denial, you have 30 days to appeal that denial if you think it is a violation of the Telecommunications Act. Here there was a denial, but they never explained the reason for the denial until 20 days after the actual act, and the court is saying, no, you have to give the reasons contemporaneous with the denial, or the period to sue has to be extended. So the lesson here is that if a municipality is going to deny an application, they should make sure that they have their reasoning in place and ready to deliver to the telecommunications company on the day that it's denied. Here, this is another case which is in a long line of cases that, you know, once a carrier shows that there's a gap in coverage, and by gap we mean from the carrier's point of view. In other words, we're not talking about a situation where a consumer can get coverage from a different provider. That's not what we're talking about when we mean a gap. What we mean by a gap is that the company cannot deliver coverage in some part of its service territory. It's a gap from their point of view. Where they have shown that there is a gap, the law is that the municipal government has to let them fill that gap. It doesn't have to approve the project that they propose, but it must allow them to fill it by some means, presumably the least intrusive alternative, okay? And that was what was at issue here. It was denied, and they successfully challenged that denial because it was an effective prohibition. They didn't let them fill that gap. So I believe that's our last case. If there are any other questions, I'll try and answer them. I'm sorry we ran a little bit over today.